Hi, myself Alfonso Jojen. I've been practicing as an environmental lawyer for a couple of years, and today we will be discussing a module on access and benefit sharing. So this module we will be learning the concept of access and benefit sharing, and also we will be discussing the international legal framework around the concept and also the national concept, and we will be looking at certain case studies. As an introduction, let's think about a book called Horticus Malabaricus. So this is a compilation of all the plants that especially in southern India, that are very relevant, and also traditional knowledge associated with those plants. This happened when a foreigner came to southern India and recorded and documented all the plants and its features, and also the knowledge especially relating to the medicinal uses of the plant relating to it. So this was the scenario once happened, but what happened is we have adopted a convention called Convention on Biological Diversity, which kind of stipulates that or reaffirms the concept of sovereign rights of states over their biological resources, and it stipulates that access to biological resources will be determined by the nations and in accordance with the national law. So what happened with that particular convention is that now if anyone wants, especially a foreigner, wants to collect a plant or an animal or any biological resources, which is also defined in Convention on Biological Diversity, if they want to come and collect that particular biological resources, then they have to comply with a certain set of regulations. And these regulations are mainly used because there's been a misappropriation of the traditional knowledge and also the traditional knowledge associated with the biological resource, and also using this particular biological resources which has originated in these particular countries and which have been conserved by the state and the communities for centuries. And what happened was a lot of states, especially economically richer state, used to convert this biological resources into commercially viable products and sell it in the market, and won't share the benefits that are from these particular products to the people who have been traditionally conserving these biological resources, or to the people who had traditional knowledge related to these biological resources. So the concept of access and benefit sharing is that when you want to access a biological resource is defined in Convention on Biological Diversity Act and also in Biological Diversity Act, that is India's legislation to the Convention on Biological Diversity, and this has been defined as plants, animals, microorganisms, their genetic resource, and very widely it has been defined. So this particular concept says that when you want to access this biological resource, a biological resource belonging to a particular country, then you need to comply with the legislations around that particular biological resources in that country, and you have to get a lot of permission from them. So this is what, and that the concept of access to biological resources. Now what is benefit sharing? As we have mentioned, the states have been trying to access or collect economically significant biological resources and also convert these biological resources into products which can be sold in the market and sold at a very high price, and this price will be while, for instance, let's take like a medicinally important plant. A lot of communities might have been involved in conservation of this medicinally important plant. And this plant is medicinally important is also a knowledge that a company has acquired from this indigenous community. So, when the community actually goes to this indigenous people or community and take this biological resource and also the knowledge associated with this biological resource and process this biological resource and make it into a medicinal form and sell it in the market, what they will do is they will just sell it and reap all the benefits out of it. They will not give back to the community or to the place where they have taken the biological resources and maybe the knowledge associated with it, the share of the benefits that they are actually obtaining from selling this particular product in the market. So, this concept of access and benefit sharing involves sharing of the accessing a biological resource, and also if there is any knowledge associated with that particular biological resource, with accessing that knowledge with the prior informed consent of the parties providing the biological resources, and sharing the benefits with these parties who have been traditionally conserving or who has the customary right over this particular knowledge. So, these are the concepts: the access with prior informed consent and sharing the benefits with mutually agreed terms. So, the concept of access and benefit sharing involves two main elements, that is prior informed consent and mutually agreed terms. So, there will be like in an ideal scenario under this convention, there will be like a state, that is a country which will be providing a biological resources, and there will be a state which will be receiving this biological resources. And what will the receiving state do with the biological resource? It will utilize this biological resources and put it in the market, or maybe research on it, or have different end uses out of it. So, you will have two parties, that is the country which is providing the biological resources and the country which is receiving the biological resources under the convention. So, this particular concept revolves around the fact that access, when the biological resource is taken, should be governed by the laws and the consent of the state that is providing the biological resources, and if there is any communities that are involved with protecting or conserving this biological resource, or if a knowledge associated with this biological resource is taken from a particular community, then this community should also be involved in giving prior informed consent to the access. So, this is what prior informed consent is. The next is, as we have already explained, mutually agreed terms. So, when you access this biological resource, you will be giving a consent saying that yes, you can take the biological resource, you can also take or like utilize the traditional knowledge or the knowledge that I have with this particular biological resource, and utilize that knowledge and make a completely new maybe like knowledge which can be patentable, or an invention which can be patentable, or a product that can be sold in the market. It is fine with us, but you have to share the benefits out of whatever you have received. So, this concept of access and benefit sharing, a fairly new concept, has been adopted in the Convention on Biological Diversity, and this convention was adopted in 1992. Most of the parties are parties to this convention except United States, which have not ratified this convention. But this especially the main players in this convention is the biologically rich countries, which involves India, Brazil and South Africa and lot of countries, and also EU is also a major player. But biological rich countries always say that you have the technology to convert a plant or an animal cell or a microorganism into something that is valuable, economically valuable in the market and can actually fetch a lot of money. But we don't have the technology. If that is so, then whenever you are accessing our biological resources, you need to take our permission, and you need to take our, you need to give the shares of whatever you are getting, be it sharing of research results or investing in our country some of your capital and setting up a new project in our country. So this concept we have discussed have been recognized firstly in the Convention on Biological Diversity, and also India has been a major player in this particular convention, and we have adopted the national mechanism for this legislation for this for access and benefit sharing, that is the Biological Diversity Act 2002. But going again to the international scenario, I think we are fairly clear with what is access and benefit sharing, what is a state provider country, who is a provider country, who is a country who is receiving the biological resources. Also, like the concepts like state sovereignty, I think I haven't covered that, but we started off our discussion saying what was the scenario before the Convention on Biological Diversity. You could collect, access biological resources, that is like plants, animals, microorganisms from any part of the world without any restrictions. You can just go in anywhere, collect the resources, you can collect the traditional knowledge associated with it, get it, steal it. You call it piracy sometimes. It's not sometimes, like you call it piracy, biopiracy. So steal it and make a new product out of it. You get all the profits out of the sale of that product, or you go on improving your knowledge and adding up on the knowledge while the knowledge was first received from one particular country or a community. So this is what this concept of access and benefit sharing is. Now we will look at the provisions in Convention on Biological Diversity Act. So as we have discussed, the Convention on Biological Diversity Act is the first convention to recognize access and benefit sharing. I also recognize that you should and also it has other mandates like conservation of biological diversity and sustainable use of biological diversity, which we will be discussing in another module. But the major thing that is related to this particular convention is the adoption of the concept of access and benefit sharing. Now let us look at the national framework that is there in India. So India in 2002 has enacted Biological Diversity Act. So what is Biological Diversity Act? Biological Diversity Act is simply our putting into the legal terms our obligations under the Convention on Biological Diversity. So this convention, it is also important to know that under the Convention on Biological Diversity, the states have been given the sovereign rights to determine the terms of access. So we were saying that now whoever who wants to collect or use a biological resources of a particular country, if I am a person belonging to another country, if I want to use a biological resource that is in another country, I cannot come and just pick it up and go and use it for different purposes. We have said that there are regulations. Those regulations are called access regulations, and with the access regulations attached is the regulations relating to benefit sharing. So this Biological Diversity Act tackles or it describes what are these regulations that are prevailing in India, because the Convention on Biological Diversity gives you the liberty gives the states the liberty to decide how their access should be and what the various means of benefit sharing would be. So, drawing from the convention, the Indian Parliament has enacted a particular legislation called Biological Diversity Act, and it has constituted 3 main statutory bodies under it. That is National Biodiversity Authority, which has jurisdiction all over India, and then you have the state biodiversity boards, which has jurisdiction over a particular state, and then you have the biological management committees, which has jurisdiction over the territorial limits of a panchayat. So, it is like the local body which associated with the governance of biodiversity. So, the Biological Diversity Act has the mandate of the access and of dealing with all the provisions relating to access and benefit sharing. And when you also look at the concept of access and benefit sharing, we have been saying that yes, you need there is access regulation, there is benefit sharing regulation. So, what is this access regulation all about? It's about how you give access to a particular biological resources. Like it says that the one of the important elements of this particular concept is free informed consent. Free informed consent means when I am giving the consent to someone else to come and collect the biological resources from my territory, then it should be free, and also I should be informed about all the all the information that are necessary to give a decision whether as to give you the access to that particular resources or not. So, when you talk about the principle of prior informed consent, it includes when the approval or whom to approach when you want an approval, and involves who is a competent authority to give approval. It also includes what is the procedure for giving consent, and the most important thing is the consent should be given prior to the access, and it should be the authority should be informed about the relevant factors that will enable it to give consent or not. So, these are some of the principles or like ingredients of prior informed consent. Now, let's say like for instance, like because since the convention on this concept of access and benefit sharing had its genesis from the convention on biological diversity, which is like an international convention where states play a main role in the entire thing. We have this particular concept like a foreigner or like a person who is not from a particular country coming and accessing your biological resources, and you engaging with that particular person and giving the access or not giving the access. So, when you have a particular for instance, if a company from a foreign from say England is coming here, and the company wants to use a particular biological resource, for instance say neem, for a particular purposes, say that is to make an insecticide, because in the traditional knowledge there is enough literature saying that neem is effective as an insecticide or has other properties. So, a company from another country A is coming to country B and seeking the permission of country B to use a particular biological resource for a particular purposes. So, what are the things that will involve in this? One, the country A should know whom to approach to seek the permission, so which is the competent authorities who has a power to give or competent authorities to approach for this access regulation. and they should also know the competent authorities who has the power to give approval. They should also know whether there are other regulations that are associated with the entire access procedure. And also while these are the information, and also they should know how long will I take to access or get permission to access biological resources from a particular country, so that the company can make an informed decision whether to apply in this country for accessing a particular biological resource or not. Wherein the party in the provider country, that is country B, or say India is giving a company from England this biological resource called neem, and it is used for certain purposes. But what does India want to know about this? India wants to know who are you and for what purpose are you asking this particular biological resource for? Is it for research, or is it to make a insecticide, like a economically a marketable product out of it? And which stage is it? Because maybe maybe the company will want to do a research first and then see the possibilities of coming out with a product, and maybe then market the product. Then all this information regarding this use of this particular access, or the purpose of this particular access, should also be given. So these are certain elements that are there while giving you a prior informed consent. So these will also signify will decide whether country wants, like India wants to give a company in England this particular right to access your biological resources. And then you have something called mutually agreed terms. Mutually agreed terms is when I am saying, okay, look, you can access the biological resource from me, but I do not think it is going to involve a lot of value addition that India cannot do, or if you train us we can do, or if you give us certain money for, or if you set up a unit of this particular unit in this particular area, so that we can do all the processing, then that will generate income for a lot, for income and employment for some people. It will be a skill or technology, exchange of technological and information regarding the technology with the country. So these are the things that we would want to negotiate with the country regarding the access. So we will say, yes, we can give the access if you give this much money. Maybe if you are going to make a product out of it, and say an insecticide or something, then you will give this much share of your profit to us. Or if you set up a processing unit in India, so that it will give employment to a lot of people, or it will give value addition or skill sharing to a lot of people in India, or it will help Indians to kind of like do this particular processing of neem, conversion of neem into an insecticide by themselves, then that can be incorporated in the agreement that will form the basis of your access permission. So all these things that we have mentioned is like share from the profit, or setting up a new industrial unit in the country which is providing the biological resources, will be benefits and sharing of benefits. These will be called sharing of benefits. So this is the mutually agreed term. So when you talk about that, how has India incorporated all these things in its Biological Diversity Act, in its legislation? That is a Biological Diversity Act. So say for example, a foreigner is coming to India, a foreign company, this company based in England is coming to India and accessing a product and accessing the biological resources, that is a neem, and also it is also accessing the traditional knowledge associated with it, because India has a traditional knowledge. It is recorded that neem is useful for this particular purposes, and based on that knowledge they are developing a product. That's so if if this company wants to do that project, then it has to come to the authority called National Biodiversity Authority, because under section 3 of the Biological Diversity Act, it says that whenever a foreigner, it's called section 3(2) persons, whenever a foreigner or a foreign company which is incorporated outside India, or an Indian company with foreign shareholding, or a non-resident Indian want to access the biological, like want to obtain a biological resources occurring in India or the knowledge associated with it, then it has to get the prior permission from the National Biodiversity Authority. So that is the first regulation that's there in the Biological Diversity Act, which is relating to access. So the appropriate forum or the competent authority to approach is the National Biodiversity Authority for people who are for section 3(2) people. Section 3(2) people, there are 4 kinds of section 3(2) people. One is for a foreigner, that is a person who is not a citizen of India. Another person is a non-resident Indian who is defined in section 2 subsection 30 of the Income Tax Act, or a body corporate or organization incorporated outside India, that is a foreign company or a organization, or an Indian company or a body corporation incorporated in India but having non-Indian participation in its shareholding or management. So these 4 categories of persons will be called as a section 3(2) persons, and if they want to access your biological resources, that is if they want to obtain the biological resources from which are occurring in India or knowledge associated with it, then they have to approach the National Biodiversity Authority. But if then, and the act also stipulates that you need to approach the National Biodiversity Authority when you are undertaking 3 kinds of biodiversity related activities. So one is research. Research is basically how you research is like a systematic study of a particular thing. You can also have a the other 2 kinds of biodiversity activity is commercial utilization, the other one is bio survey and bio-utilization. All these activities are defined in the Biological Diversity Act. So the research is when you want to conduct a study on a biological bioresources. So we are talking about what is commercial utilization. So commercial utilization is defined in Biological Diversity Act as end uses of biological resources for commercial utilization, such as drugs, industrial enzymes, food flavors, fragrance, and there are a lot of examples there, but does not include conventional breeding or traditional practices in use in agriculture, horticulture, poultry, dairy farming, etc. So which basically means that when you are using a biological resources to make a drug or to make a industrial enzyme or food flavor or fragrance, then that is commercial utilization. And the main part of the definition is what is whether that particular thing is an end use of the biological resources. And now this and you keep in mind the exemption is that it does not involve conventional breeding or traditional practices in agriculture, horticulture and all. So if the section 3(2) persons are accessing the biological or obtaining the biological resources occurring in India for all these purposes, then they have to apply to the National Biodiversity Authority. If that is commercial utilization, and also there is another regulation if this biological resources is used for biosurvey or bio-utilization, then also they have to apply to the National Biodiversity Authority. So what is biosurvey and bio-utilization? It is basically survey or collection of species or subspecies, genes, components, etc., and maybe using a if you are making an inventory of the species that you have collected, then that also requires permission, and it's not just permission, it's prior permission from the National Biodiversity Authority. Linking it with the elements which says that the free prior informed consent should be prior to the access. This prior permission has a very important significance. The word prior has an important significance because before accessing you have to approach the National Biodiversity Authority. So, first regulation is with respect to section these activities. Also there are other regulations for which you need National Biodiversity Authority's permission. Also you need the state biodiversity's permission. Under the Act, you have two regulatory bodies, that is the National Biodiversity Authority and you have the State Biodiversity Board. This National Biodiversity Authority will be looking after section 3, section 4, section 6, and the State Biodiversity Authority will be looking into section 7 of the Act. Under their regulatory part, they have other powers as well which are elaborated in the Act. So, section 3 we have discussed. Section 3 means whenever a section 3(2) person wants to collect or obtain biological resources for the three purposes that we have discussed, they have to approach the National Biodiversity Authority and they have to get the permission from the National Biodiversity Authority. And section 4 says that when you want to transfer, who wants to transfer? Anyone who wants to transfer to a section, the research result of a project, then you need the permission from the and transfer it to a section 3(2) person, then you need the permission, prior permission from the National Biodiversity Authority. So, when you are transferring research result relating to any biological resources occurring in India or obtained from India, this occurrence is very important because India should be the provider country and for monetary consideration or otherwise. So, if you are transferring the research result, also you have to apply to the National Biodiversity Authority before such transfer, because you need the prior permission from the National Biodiversity Authority. Now, National Biodiversity Authority has another regulatory power, that is with respect to section 6. What is section 6? Section 6 means that you need whenever you are applying for any intellectual property, be it patent or anything else, you need the prior permission from the National Biodiversity Authority. So, this patent should be, so this intellectual property should be over an invention based on a research or information on a biological resource obtained from India. So, if you have done an research on a biological resource obtained from India and if you have an invention, then you have to apply to the National Biodiversity Authority. And then you have, but there is a proviso which says that even if you have applied, this is with respect to patents only, it says that even if you apply to National Biodiversity, to a patent office, it does not matter. Before the grant, they use the term sealing, but it is now sealing, that process is gone. Now, before the grant, they have to get the permission from National Biodiversity Authority. So, section 6 has certain problems because you say before you apply for any intellectual property rights for an invention. So, whether the inventions, other inventions like your geographical indication, other IPRs like geographical indicator or your copyright, whether these intellectual property rights are included within the section ambit of section 6 is kind of contentious, because this, after the intellectual property rights, the provision, section 6 provision uses the word invention. So, whether it is confined to patents or like the plant varieties patents like breeders right and everything, or whether it includes copyright or geographical indicators, is something that we have to, some guidelines have to be given by the parliament itself, because it's in the legislation. But there are exceptions to this section. The Plant Variety Protection Act of Indian Plant Variety Protection Act does not need permission from this, because it already has this existing benefit sharing mechanism. And now we've kind of covered section 3 and section 4 and section 6. And what is section 5 all about? Section 5 is about an exception to section 3 and section 4, which says that collaborative research projects will not require the prior permission from National Biodiversity Authority. Collaborative project, if it falls in kind of like complies with all the conditions that are listed, that is if there's a guideline which says that there's a guideline that is issued by the central government. If your collaborative research project comply with that guideline, and if you have got approval of the central government, then you don't need the permission of National Biodiversity Authority under section 3 and section 4. So this is section 3, section 4 and section 5 and section 6. Now we come to section 7, which is the regulatory power of the State Biodiversity Board. So what is the regulatory power of the State Biodiversity Board? The it says that the State Biodiversity Board should be, no persons are Indian citizens or the body corporates enlisted incorporated in India will have to give prior intimation to the State Biodiversity Board if they are obtaining any biological resources occurring in that particular state. So this is section 7 is confined to Indian citizens, and also section 7 is confined to certain activities. Indian citizen does not require to give prior intimation. It's different. One is prior intimation, another is prior permission. So the Indian citizens or bodies and Indian corporate bodies won't require permission, but it only requires intimation, and this intimation is only for certain biodiversity activities, that is whenever they are using commercial utilization. Undertaking commercial utilization or undertaking biosurvey or bioutilization for commercial utilization. So that is your section 3, 4, 5, 6 and 7. Now that is relating to your access. We kind of talked about the concept of access and benefit sharing. Now how does the benefit sharing come into picture, and what is the mutually agreed terms that these guys can do, and who is the appropriate body giving the consent for this? That is discussed in section 20, 19, 20 and 21, and benefit sharing is kind of related to or given in section 21, and section 21 it says that it is a mandate of the national biodiversity. Benefit sharing is already defined in your biological diversity act. It says that it is determined, benefit sharing is a benefit sharing determined by National Biodiversity Authority under section 21. Section 21 refers to section 19 and 20, and section 19 and 20 refers to section 3, 4 and 6, and section 20 is when anyone wants to transfer this permission they have obtained under section 19, that is 3, 4 and 6. So with respect to these, the National Biodiversity Authority, it has an obligation to enter into to mutually ensure that there are terms of a condition which kind of ensure that equitable sharing of benefits arising from uses of the access biological resources will be ensured, and this equitable sharing of resources should be in accordance with mutually agreed terms. Who will be the parties? The parties will be the person accessing, applying for the approval, and the local bodies and the benefit claimers. Benefit claimers are people who are conserving the biological resources or who have been keeping the information related to biological resources. The term is also defined in Biological Diversity Act, and these are the people who have to be involved in the mutually agreed terms. And what are the benefit sharing modes of benefit sharing? There are non-monetary and not monetary, which we have already told in the previous discussion, which is like if you want to share in the profit, or if you want to set up a venture capital, or if you want to set up a unit here, all this will come under benefit sharing, and all these should be in accordance with the mutually agreed terms, which basically means that the National Biodiversity Authority has to consult the local bodies and the benefit claimers. And also there is another provision in section 41 says that the biodiversity management committees, which are also a statutory body established under the act, have to be consulted whenever they are accessing, whenever NBA or SVB is making a decision over the access of these resources from within their jurisdiction. So they have to be consulted also, and a lot of times local bodies will be BMCs will be consulted instead of the local bodies. That is what the practice have been. So this is how the entire regulation and access mechanism under the Indian regulation goes. Also you have, if any one of you, I mean if these provisions are violated, then it is a cognizable offence. Now we can kind of like skip to the case studies, which is like, first of all we will discuss a Kani tribe case, which is an example for bioprospecting. The other one is a BT brinjal case, which is a example of biopiracy. So in Kani tribe, what happened? It happened before, much before the CBD and all. What happened was these guys wanted like a, and there were no provider country or like there were no other countries. It happened within the country. So Kanis are like a small tribal groups in southern India, and they had a particular traditional knowledge with a particular plant, which is called Arogya Pacha. So what happened is the Tropical Botanical Garden and Research Institute, they kind of like went and they kind of came to know about this particular knowledge, and they kind of decided that there is a scope to kind of like make a product out of this particular biological resources and also the knowledge associated with it. So they kind of like made a contract with the Arogya Coimbatore Ari Vaidyashala, and there was an agreement, like just like a mutually agreed terms and all. They had an agreement wherein the profits were also given to these Kani tribes. They had a share in the profits, and also these guys were supplying the biological resources to the particular company which developed the drug, which is the drug is called Jeevani, and this company is called the Arya Vaidyashala. That is a Kani tribe example. Now we have the BT brinjal example, which is a case of biopiracy, which is when the section 3(2) company like Mahicom, Maharashtra Seed company, because it had a foreign shareholding capital, it had Monsanto had invested in this particular company. So it fell under the definition of section 3(2) company. They accessed local varieties of brinjal from Karnataka, and without the permission of National Biodiversity Act, for developing for doing research and also for commercial utilization, because they were developing a BT insect resistant BT brinjal variety, for which they haven't had received the permission from the National Biodiversity Authority. So the National Biodiversity Authority, what they did was they filed a complaint against it. The Maharashtra Seed Company and also the University of Agriculture Sciences, which kind of gave the local brinjal to the company. Also there was like a party who was facilitating this entire process, that party was also made accused, and this case is still pending in the court, but this is a case of biopiracy that is there. So today we have discussed the concept of access and benefit sharing, and regulations relating to access, regulation relating to benefit sharing, elements of access, elements of benefit sharing, and the international and the national regulations, the important regulations, and also certain case studies. Hope everyone understood and